Hello everyone, in this presentation, we will be discussing question 1, which involves a partnership dispute under the Partnership Act 1961. Partnership law is very important because it determines who is legally responsible for a business's decisions, debts and obligations. Understanding these rules can help prevent misunderstandings and financial liabilities. Today we will focus on a real-life inspired scenario where legal principles are applied to determine whether a person is a partner and whether they are personally liable for a firm's debts. We will analyze the case using the IRAC method, which stands for I for issue, R for rule, A for application, C for conclusion. This case helps us understand who is legally responsible for a firm's debts and the difference between a partner and a manager. The case involves Arnis, Arissa, and Orfa, who are partners in 3A Enterprise. They appointed Sophia to assist in managing the business. As part of her contract, Sophia was entitled to 5% of the business profit. It is important to note, Sophia did not contribute capital. She did not have authority to sign contracts or make major decisions. Her role was only to assist in management. Initially, the business performed moderately well, but later it suffered huge losses, and the firm was sued by creditors. The main issues are: 1. Whether Sophia is considered a partner of 3A Enterprise because she receives 5% of the profits. 2. Whether if Sophia is considered a partner, she is personally liable for the firm's debts. It is important to understand that partners have joint and several liability, meaning they could be responsible for all the firm's debts. Managers or employees, however, are not personally liable unless they act outside their authority. Next, we look at the rule under Law 1 Section 3(1) Partnership Act 1961. Partnership is a relationship between persons carrying on a business in common with a view to profit. A partner usually contributes capital, shares profits and losses, participates in management, has authority to bind the firm. 2 Section 4(c) Partnership Act 1961. Receiving a share of profits alone does not make someone a partner, especially if it is remuneration, salary or commission for services. 3 Case Law Cox v. Hickman, 1860. Profit sharing is not conclusive evidence of partnership. What matters is whether the person carries on business as a principal. Applying the law to the facts, Sophia only assisted in management, not as a business owner. She received 5% of profits, which was remuneration, not capital or ownership. Sophia did not contribute capital, did not share losses, did not have authority to bind the firm. Based on Section 4(c) and Cox v. Hickman, she does not meet the criteria of a partner. She is legally a manager receiving payment for services, not a partner. In conclusion, Sophia is not a partner in 3A Enterprise. She is not personally liable for the firm's debts. Receiving 5% of profits does not create personal liability. Thus, Sophia is legally protected from the firm's losses. Overall, this chapter shows that a partnership depends not on labels or titles, but on the actual facts and conduct of the parties involved. Under Section 3(1) of the Partnership Act, a partnership exists only when a business is carried on in common with a view of profit, and all three elements must be present. Section 4 states that profit sharing is prima facie evidence of a partnership, but this can be rebutted if the relationship is actually employer-employee or debtor-creditor. As seen in Sophia's case, partners also face unlimited liability, meaning personal assets may be used to pay business debts. Lastly, mutual agency means each partner can bind the firm through acts done in the ordinary course of business. These principles show the serious legal consequences of being regarded as a partner. So that's the end of our presentation. Thank you for listening.